Imagine walking into a beautifully designed care facility where the walls are warm with pastel colors, the windows let in floods of natural light, and the air smells of fresh-baked cookies. Residents are laughing in the common area, playing bingo, or just enjoying each other's company. Despite the harmony and contentment, each person in this scene is considered, by law, to be deprived of liberty. Yes, even if they've never once asked to leave or expressed any dissatisfaction with their lives. It sounds strange, doesn't it? How can someone be deprived of liberty in a place where they're happy? The contradiction lies in a legal test that doesn't care about happiness. This isn't merely a hypothetical, it's a real paradox unraveling in care facilities across the UK. The law defines deprivation of liberty under objective terms, not subjective feelings. So, even if someone is living their best life, they can still be legally deprived of their freedom. This story starts with a landmark case, PV Cheshire West and Chester Council, which set the stage for this baffling legal standard. In 2014, the UK Supreme Court's decision in PV Cheshire West and Chester Council created waves. The court introduced an objective test to determine deprivation of liberty in care arrangements. The essence? A person's liberty is legally deprived if they cannot leave without permission and are under continuous supervision and control. It sounds straightforward until you realize it doesn't consider the person's feelings or desires. Let's take a closer look at the criteria. The court emphasized the acid test, which checks if a person is subject to continuous supervision and not free to leave. Notice what's missing? The consent or happiness of the individual. This means that even if someone willingly lives in a care home, enjoying every moment, they are still legally deprived of liberty. Consider a historical example from the same case. Megan, a young woman with learning disabilities, thrived in a care home where she had friends and activities she loved. But because she needed supervision and couldn't leave unaccompanied, she was legally considered deprived of liberty. This wasn't unique to Megan, thousands found themselves in similar situations post-ruling. The intention was protection, but in practice, it paints a bizarre picture. Why does this strange legal framework exist? The driving force behind the law is protection. It aims to safeguard individuals who might be vulnerable to coercion or neglect. The objective test serves as a safeguard against abuse, ensuring that people in care are there for the right reasons. But this broad brush can sometimes paint over shades of grey. Who benefits from this? At face value, it seems like the residents lose out. But dig deeper, and you see the safety net it provides for family members and carers. It offers them peace of mind, ensuring that facilities are held to account for the care provided. But herein lies the contradiction. What if the same system that protects can also restrict unnecessarily? The law's defenders argue it prevents potential abuse. In their view, a uniform standard is crucial because subjective measures can be easily manipulated. Yet, in trying to cover all bases, the law may overlook individual experiences. It assumes all deprivation of liberty is negative, which isn't always the case in environments where residents feel safe and cherished. What does this mean for people living in these circumstances? Take Oliver, a cheerful man with Down syndrome who loves his home at Sunnyside Care. He's never once desired to leave, finding joy in the gardens, the art classes, and the community dinners. Yet, legally speaking, he's not free. His contentment is overshadowed by an invisible legal label. Families, too, find themselves confused. Oliver's sister, Emily, struggles to comprehend why bureaucracy hangs over his happiness. For her, the law feels like an intrusion into their personal lives, a constant reminder that someone else defines her brother's freedom. This impacts the ordinary person directly. It challenges our understanding of freedom and care, raising questions about the balance between protection and autonomy. Should a legal framework dictate our perception of liberty when it contradicts lived experiences? So, what needs to change? The law should evolve to recognize when care and consent coexist peacefully. A more nuanced approach would respect the subjective experiences of those in care. It would differentiate between situations where supervision is a necessity and where it enhances life quality. We need to advocate for legal flexibility that accommodates individual narratives. The system should be able to distinguish between protection and restriction, ensuring no one is needlessly labeled as deprived of liberty. This requires a shift from strict objective assessments to a more balanced view that values personal contentment and agency. The call to action? Engage with policymakers. Raise awareness. Encourage dialogue about what true liberty means for those in care. Legal standards should reflect the diversity of human experiences, not just safeguard against the worst scenarios. We leave you with this thought: the senseless part is not the protection against deprivation of liberty. It is the failure to recognize freedom within care.